All right, good evening.
Hi, good evening.
My name is Professor Laura Friedman. I am an adjunct professor here at Trinity Law School, where I teach civil procedure, legal writing 3. I'm teaching contract drafting this semester as well, and I teach civil litigation skills and a couple other classes. I have been teaching here for approximately 4 years. I have a solo practice in the city of Orange where I do general civil litigation and probate, estate planning, and conservatorships. And I am an alum of TLS. I graduated in 2008. So, and this is my second career. I was a paralegal for a really long time. So, welcome to the essay writing workshop. And let's get started. So I think this goes without saying is before you even get to the exam writing portion, you need to be prepared and pay attention in class, all right? Because you need to be there both physically and mentally, which means that you have to be prepared in doing your reading prior to class and not just reading cases. Oh, and by the way, the outlines that I'm going to be handing out in class are the slides, so don't worry about that. It's not just reading your cases, but understanding and doing extra reading so that you understand the specific topic that's going to be discussed in class. So, I mean, because that's going to help with your understanding of the rules better and the application of the rules to different fact patterns. The other thing, too, is your professors are going to go over material that's testable both in class and on the bar exam. So listen carefully. Some professors give you exam approaches. And so if you're not in class, or if you're texting, or if you are on, playing games online or doing something, you're going to miss those little subtleties that are spoken of in class, and that's going to give you a severe disadvantage when you take the exam. Some professors will give you hints on what areas are going to be tested. I had a professor here who told me that the only things that he tests on are the subjects that are covered in the case book. So if there was a case, then that could potentially be a fact pattern for the final or the midterm. And he was absolutely being honest, because the midterm came directly out of one of the cases, and the final were variations of the cases that we had read. Those were our final exams, and the students that had read and understood and took what he said to heart did really well on the exam. So that's really important. Your preparation for your exams starts the minute you're in class. So make sure you're there. Another thing that seems very rudimentary is study, right? Most law students completely underestimate the material that is covered in the semester. And so what happens is you start getting into panic mode because you have not really taken the time to see the big picture and how much material is covered. You need to understand the rules, and more importantly, you need to understand each of the rules and the elements that make up the rules. The more you are prepared, the less anxiety that you're going to have when it comes time to taking your test. All right, and so knowing and understanding the rules is a big part of the exam writing, but just knowing and understanding the rules is not enough. You need to know how to take that rule or rules and fit them into different fact patterns. For example, is there more than one way an assault can occur? Yes. Is there more than one way someone can be negligent? Yes. There's not just going to be one way. So the fact pattern that you get on the midterm, you're not going to be able to memorize that because and have your approach, because facts might change, and you have to be able to understand those rules and the elements of those rules to apply them to different fact patterns. And the key to understanding how to use one rule for a different fact pattern is to read prior exams and read your cases, right? If you have a good case book that your professor's using, you'll see all of the various subtleties of one area or one rule. Same thing with getting your hands on prior exams, because then you're going to see all the different ways that that topic or that issue or that rule can be tested. The same thing goes with multi-states. It doesn't just go for exam writing. When you read the multi-states, you can see fact patterns that are potentially testable in an essay. And so the key is, the more exams that you get your hands on, the more multi-states that you see and that you read, the more likely it is you're going to be able to issue spot. And that is a key in a successful exam writing. The next thing is have an approach. All right, since there's so much material to remember for each class, it's imperative to have an exam approach for each subject. And not only for each subject, for each different area of the law that's covered in that semester, or if it's a year-long class, for that year. All right, so you want to organize or have an exam approach for the whole entire course, and then have mini exam approaches for the different areas. So for example, torts, you would have intentional torts, negligence, strict liability, defamation or invasion of privacy, business torts, that kind of thing. That's your whole class, right, in torts. And in all of those areas, you want to have exam approaches for every single one of those. So you have an overall approach for the area, torts, contracts, what have you, crim law, any class, and then mini approaches for each of the subjects. And I'll give you an example. So this is really simple. Intentional torts, ABC fit. You can have a mnemonic, all right? And mnemonics are fantastic because it's a great way to organize that information in a manageable way. And I highly recommend them. I use mnemonics all through law school, and I use them on the bar exam. As a matter of fact, there was several times on the bar exam that had I not had my mnemonic, I would have been completely disorganized and I wouldn't have been able to answer the question. So you carry, your bar review starts the first day that you are in class. And so getting into good habits now, it'll be second nature when you get to the bar exam. So for example, ABC fit, here it is. There is my exam approach. There's my exam approach. My mouse isn't working. ABC fit. So I write that out. All right, so before even that happens, right before the exam begins, make sure you listen closely to the instructions provided by your proctor. The reason why I'm stressing this is because in the bar exam, you're in a room of 3,000 people, and there is a guy that's standing on a podium or on I think one time it was a scissor lift or podium. And he's got a megaphone or a microphone, and he's going through the instructions, and you have about 20 or 30 minutes of instructions, and they don't go over it again. and you can't ask questions. You cannot raise your hand and say, I didn't get that. So, like I said, start the good habits in law school. Listen to your proctor. If you're handwriting your exam, make sure you list your correct exam ID on the cover of the blue book. Make sure you list your correct ID on the honor page. You're going to have to go through a similar thing on the bar exam. So listen to the instructions. All right. So they call begin. All right. That's when the panic sets in, right? No. Just be calm, and the first thing that I do is read the call of the question. That is important. And the reason why you get into the habit of reading the call of the question is because when you're on the bar exam, you have no idea when you flip open that book what area of the law they're going to be testing on. So if you read the call of the question, it should give you a clue of what area of the law that they're going to be testing on. Like I said, start these habits now. Read the call of the question, you understand, all right? Is the defendant going to be liable to the plaintiff for negligence? Discuss. Or, what defenses can the defendant raise, or what have you. So look at the call of the question. Again, you have no idea what subject's going to be on the bar exam, so that's really important. Read the call of the question carefully. Make sure you understand what they want you to answer, and only answer that call. All right. It's the bar exam and us professors are not only testing your ability to do legal analysis. Reading comprehension is probably half important, about 50% of the importance. All right, you've got to read carefully. You have to understand what you're reading, because if you gloss over it and you don't understand, you're not going to be answering the question properly. You're going to start writing on something, and then all of a sudden, halfway through your essay, you're going to realize that that is a dead end, and you've wasted all of this time writing on something that you shouldn't have been writing on. So make sure you understand the call of the question. All right, so write out your exam approach. You should be practicing your exam approach all the time. All right, and so this is essentially legalized cheating if you have it all in your head, right? The exam begins, you take your scratch paper and you write out your exam approach for the entire class. All right, that way you have all of the issues that could be covered in that exam listed on scratch paper. I've been doing this long enough, and I've seen where my students will start writing their exam approaches on their computer. And this is one of my pet peeves that, there's nothing that says you can't do that, but what I find is that my students will spend so much time writing their exam approach on the computer and then trying to fit all of the issues and the rules within that approach on the computer, and they either write on non-issues or they miss things, or they're wasting time deleting everything that's not an issue. My recommendation is don't do that and don't get in the habit. They give you scratch paper, it's faster to write it out, and then just leave it at that. All right, so write out your exam approach. You've read the call of the question, you've written out your exam approach. You could write your exam approach first and then read the call of the question. There's no right or wrong way. It's however you feel comfortable. And then read the question to understand the fact pattern and how those facts will play into answering the call of the question. Now, at this point, I'm not writing anything. I'm reading the call of the question. I'm reading the question so that I can understand what is going on here. All right? And so things might start popping out, but I'm not writing. It's a hard thing to do, to just not write. But I want to make sure I understand what's going on. And then I read the question again. So the second time, now I'm issue spotting. And so what you should be doing is using your exam approach in conjunction with what you're seeing on the exam. So if you've got your exam approach, ABC fit, and let's say we're doing an intentional tort question, you know, what issues are matching up? Do I see an assault? What facts? Where are the facts? Where are the facts? Scrutinize each sentence or word to determine if it raises, and that should say an issue, not an issue. And look at your outline. And when you see a fact or a word that raises an issue, circle it on your outline, write down the fact. Right? I'll circle assault and I'll write the couple little sentences or a couple little words of the facts, not the whole thing. And I go through this with every single issue. You can also do this directly on the exam if you want. I know some students will do that. They'll see a word and then they'll circle it and then they'll put a line and then put what the issue is. Whatever you feel comfortable with, just start practicing the different ways so that you have an approach and you're comfortable with that, and experiment, whatever works for you. Go through the entire exam word for word and match up the facts with the issues on your outline. Cross out any issues on your outline that aren't present in the essay. And the reason why I tell you to go word for word is because I have been writing exams for the last 4 years, and I will tell you that every single word or every sentence is going to raise an issue. It could be a word, it could be a sentence. There's very rare times where I will put in facts for background information. Now, I teach civil procedure, sometimes I have to do that, but those facts will attach to an issue in some way, shape, or form. The bar examiners are doing the same thing, and your professors are doing the same thing. All right? So you scrutinize every single sentence. All right? Does this word raise an issue? Does this sentence raise an issue? And you have to be methodical about that. Now, you can see that if you just try and do this at exam time, that's not going to help you. You have to start writing, and you have to start issue spotting. You have to start doing the work well beforehand. So let me give you an example. So we're taking assault from the ABC fit. All right? Intentional. D was angry at P. Apprehension of immediate harmful or offensive touching. P was facing D when he threw the rock. D yelled at P that he was going to throw the rock at P. P tried to duck to get out of the way. Was there 2 assaults? D's words and D's acts. I just put a question mark because that might be something that I need to talk about. You know, battery, the rock hit P. All right, and I cross out conversion, false imprisonment, intentional infliction of emotional distress, trespass to chattels, and trespass to land. Right? Because I didn't see that. Does that make sense to you? All right. So the entire process of issue spotting and matching the words with, matching facts with the words for the causes of action and outlining our answer should take approximately 15 to 20 minutes. Now, this presupposes that you know the rules cold. All right, you've got to know those rules cold, and you have to be able to go through an exam and be able to issue spot and circle the issues that are there, raise any sub-issues that arise out of that using the facts, and negate the issues that aren't there. I know this is really hard. It seems like it's going to be really hard. You say 15 or 20 minutes. That only gives me, 20 minutes, 25, 30 minutes to write. That's not enough time. Yes, it is. If you have been diligent and you've learned your rules and you've been practicing writing, you'll be able to do this. 15, 20 minutes outlining, because that way you've organized your exam on your outline and you can just start typing. You've already done the work. So you're just looking at your outline and then typing. And the other thing too is the peer pressure sets in, all right? And what I mean by that is you are going to be in class and you're going to hear people starting to type immediately. And that's happened, hasn't it? And that freaks you out, right? Because they're typing. I never let that bother me, all right? They are doing what they need to do. I know what I need to do. This is how I was taught, and this has always worked. This is an exam approach that I've learned from several different bar review classes when I first was in law school and during bar exams. So, this has taken me a long time to develop, but it's already been developed before by other people, and I just did what they told me to do. So again, hold course, don't panic, and don't abandon the plan when this happens, when you see students just typing furiously. I'll give you a war story. I was in a biz orgs class, final exam, and I looked at the exam, I was issue spotting outline, and nobody typed for 20 minutes. There was no writing for 20 minutes. And that was a little eerie. So, but we all got through the exam and everything was fine. So everybody was using that approach. Yes?
So you for like a racehorse exam, you're supposed to do this for 20,
Yes, you can do it.
Really?
You have to practice. That's the thing, is that I find that my students don't want to write. You have to practice this. You are not going to get this overnight. Number one, it's a completely new way of writing. It's a completely new way of thinking. And the only way that you get good at this is to practice. You get your hands on every single exam that you can find and you just start writing it out using that approach. It might take you 15 minutes. You might remember everything in your approach and be able to issue spot quickly. It might take you 10 minutes. It could take you a little longer, but what I'm saying is normal. It's 15 to 20 minutes, even on a racehorse, because you should know those rules cold. And if you've been practicing writing, it shouldn't be a problem for you. You can spot those issues, you can get those out on your outline, match up the facts, and then just start typing.
So when you write now, I'm sorry.
Go ahead.
So when you're writing now on your sheet of paper, you want to put all the reasonings that are supporting that element.
Well, I would just put a couple little facts. You don't have to write.
Go back to the fact pattern and pull more out from it.
I would just double check and make sure, and you want to write the exact facts down. All right, that's a big thing. I'm not suggesting that you write whole sentences out next to your outline, but just enough facts that are going to support that element. And that way you can see it on your outline and then you can just start typing. That way you have everything. Again, approaching your essays in this manner keeps you organized and it ensures that you're not missing any issues. And like I said, this is a hard thing to learn and it takes practice. You cannot do this overnight. The students that I can tell my students who are practice writing. I absolutely can tell, and I can tell the students who aren't. And it's really easy because just the writing is completely different. And so that's what I'm suggesting is this takes a lot of time. It takes dedication. It takes practice. You can't learn this overnight. And you've got to practice doing this over and over and in every class. So it's just, you go through this process in every single class in law school. And some classes lend itself easier to this approach than others. Some classes, you're going to have to determine what the approach is, because the approach isn't going to be like ABC fit or in contracts, offer acceptance consideration. Some of the classes like con law and real property, it's a little bit more, and you have to do a little bit more work to get your approaches down. But it's doable, obviously. Yes?
You said that the writing is completely different. How is it different? Can you give some specific examples?
Yes, because you're doing legal analysis. What you're doing is you are looking at a fact pattern, and you are not concluding. You are going through a process to determine whether or not there is a cause of action present. So in the case of an assault, you know what the definition of assault is, right?
Yes.
Okay. Or let me give you another one. Negligence, all right? Duty, breach, actual cause, proximate cause, and damages, right? You go through the duty rule, right? And you look at the facts to see whether or not the defendant owed the plaintiff a duty. And you're matching up those facts. Is it the general duty rule? Is there a special duty? Is it a landowner occupier? And you're going through those facts to determine whether or not there's a duty. All right? Then you're going breach, proximate cause, actual cause, to determine whether or not the defendant was negligent. Now, do you have to conclude a specific way? One person can say no, that the defendant wasn't negligent. Another person can say, yes, the defendant was negligent. It's how you argue those facts. Because what happens is, and this is what I tell my students, why you're learning this is because when you are an attorney and I meet with a client for the first time, my client comes in and tells me a story. And they want to know if they can sue, or if what can they do? What are their rights? And I have to issue spot in my head. I have to go through all of their facts and say, yes, this could possibly be a claim. You could possibly have a claim for this or that or that. That's the skill that you're learning. And your legal analysis is completely different because you're not concluding. Two people can look at the same set of facts in law and determine two different ways. It's how you argue it. Because when you're in front of a jury, you have the plaintiff and the defendant. Plaintiff's arguing this, defendant's arguing this. They're arguing the same law, but they're looking at it differently, and that's what you're being trained to do. So it's completely different, because when you're an undergrad, you're taught to conclude, right? You come to a conclusion. Yes?
Can you give us an example? I'm stuck on the whole conclusory thing, because when I took the torts test, I had a lot of conclusory ideas. Can you give us an example, or quick example of one that is and one that isn't a sentence?
Okay, so what I tell my students is, if you say, here, I start, and some professors don't like this, but I always put here, or in this case, when D did something to P, he caused this because. The because is the why. When you explain why, you're not being conclusory. If you say, if it's A took the rock and threw it towards the defendant or towards the plaintiff, therefore an assault happened. That's being conclusory. You have to explain why. Why? Why did that happen?
Or something like that.
Because why? Why was an assault committed?
Because it's really going to
The because or yes. And that's my suggestions. Some professors want you to use other words than because, but some kind of conjunction or some kind of explanation of why. So you're not being conclusory. All right, time to write your essay. Start out with the title of the lawsuit, right? And that goes in every single class. And if there are 2 or more calls of the question, make sure you head note which call of the question you're answering and go in order. It's just so much easier to answer the first question first, then the second question, or the third. Sometimes in Civ Pro we have 4 calls of the question. So it just take them in order. Just a lot easier to organize and handle. So for example, what causes of action can Paula allege against Don? What defenses can Don claim? All right. Likewise, if there are 2 or more lawsuits, go in order. It's just so much easier. Why reinvent the wheel? And why get the grader aggravated? Because when we're grading, that's what I'm looking for. At least I am. I'm looking to see that things are in order. And so it just makes it a lot easier. Part of this is being very organized and head noting and letting that reader know that you know what you're talking about, that you've got a grasp on this subject. All right, so you look at your outline and what's the first issue you spotted? Start to write on that issue, all right? Use IRAC, right? Issue is going to be head noted, negligence, all right? State the rule, and then I've stated the rule for negligence. Negligence is the failure to conform one's conduct as a reasonable person would under the same or similar circumstances. The prima facie elements of negligence are duty, breach, actual cause, proximate cause, and damages. Right? You've got to know those rules cold. Absolutely cold. Now, I know when you're in your first year, it's really hard to underline and bold things because you're typing, and that's a skill. But it's good if you can get that habit early to underline the key elements because they pop off the paper. And that way when I'm grading or you have another professor grading or the bar graders are grading, they're popping right off. So I know you know the rule, right? And then you're going to take those elements and you're going to be, especially the prima facie elements, and you're going to be, this is your exam. This is what you're going to be writing on, and this is the order you're going to be writing on. So knowing the exact rules is kind of a cheat sheet because it tells you what you need to write on. And that way you're not missing any issues. All right, so again, knowing the rules gives you the issues. So the next issue you're going to be writing on is duty. And after you've defined the issue, stated the rule, next comes to the analysis. And the key to an effective analysis is to weave in the elements using the exact facts to frame a cogent argument. And it's not easy. It takes practice. And it also takes discipline of getting your mind around thinking in this manner. That's why you're reading your cases. The analysis in the cases are so important because it's teaching you how to do legal analysis. How are they weaving in those facts with the elements to come up with a conclusion? Make sure you're not being conclusory, and I think we went over that. And underline the key elements of the definition in your analysis. So, I'm going to give you an example. Offer is an outward manifestation of present contractual intent containing definite and certain terms communicated to the offeree. Definite and certain terms include quantity, time, interested parties, subject matter, and price. So I didn't give you the question, but I want you to see how to weave in the facts with the analysis. So here we go. Betty will argue that when Sam sent Betty the original and one copy of the purchase agreement, he indicated his outward manifestation of present intent to be bound to the terms of the offer in selling his business to Betty. The offer stipulated Sam would sell his interior design business, parentheses, quantity of one business and subject matter, the interior design business, to Betty, the interested party, for the contracted purchase price. Now, do you see how I've woven in the rules with the facts? All right, so the facts in this case do not indicate the purchase price, but the language of the purchase agreement, and you read the purchase agreement, payment of the purchase price indicates the price was agreed upon prior to sending the payment. All right, so some facts can be inferred. All right, and that takes, you know, if you're reading that contract and there's a price in there, or it says the purchase price, then you can infer some things that make sense just from how the question's written, but you do not want to make up facts. Making up facts and inferring things are completely different. So the facts do not indicate a purchase price, but the language of the purchase agreement, payment of the purchase price, indicates the price was agreed upon prior to sending the payment. The time can also be inferred by the facts that the offer was sent the next day and Betty signed and returned the payment immediately. Thus, the terms of the offer were definite and certain. Betty received the offer. Sam sent Betty the purchase agreement, one copy indicating the offer was in writing. Conclusion, there's a valid offer. So I'm not being conclusion, I'm explaining everything and I'm weaving in the facts with the elements of that definition. And so you can see it, you need to do, it's practice. You have to practice doing this. All right, so as you can see, the elements of the offer were woven in with the facts to come to a reasoned logical analysis that there was a valid offer made. And as was seen in the prior slides, the analysis contained a mini conclusion. And so each issue should contain a mini conclusion and our transition phrase to bring you to the next issue. Right, so that's important. So go through the IRAC approach for each issue you spotted on the exam. Make sure you go through your outline to ensure you have written all the issues. Now, when I was in my first year of law school, this was a problem for me, okay? So I had my exam approach. I went through and I issue spotted and wrote the facts and everything, and I thought I had it in my head, and I started to type, and I wouldn't go back and look at my outline. And invariably, I would miss an issue. And so I learned that the hard way my first semester, and still kind of into the second semester, and then I just had to force myself to go back and look at my outline. And what I started to do was cross out everything that I had started typing on, and to make sure everything was there. Once you've completed your full analysis of all of the issues and come to a conclusion, the conclusion should answer the call of the question. All right, is D liable, or D is liable for P for negligence, or D breached his contract. Now, you don't have to. You can say, no, D is not liable for negligence. If that's what the conclusion you came to after doing a thorough analysis, that's fine. But as professors and as the bar graders are going to be looking to see how you came to that analysis or conclusion through your analysis. All right, be cognizant of the time. Each essay is 1 hour. So the first, again, 15 minutes should be allocated to reading the call of the question twice, issue spotting, and outlining. The next 25 or 30 minutes or so should be spent on writing the exam. And try to get your exam completed with at least 5 minutes remaining. And then use that time to spell check, to double check your outline, Make sure you've written on all the issues. I mean, you just kind of need that time. And read your exam, okay? Make sure that it makes sense. Because sometimes when you're in the heat of the moment, and I know how this is from personal experience, you start writing something and then you read it again and it doesn't make sense. And I can't tell you how many exams I've read where my students don't leave 5 minutes left and I've got a paragraph of I can't even read it. I don't know what they're saying. The other thing too is I don't count my students off for spelling errors, but I will tell you that spelling errors on the exam are on your exam that you've written is your answer is distracting. So make sure that that's why I tell my students to do spell check, because if every other word is misspelled as a grader, it's frustrating, because then I have to figure out what that word is, especially if you're typing, furiously, and then you start misspelling words. Don't panic. So if something occurs during the exam, your laptop crashes, it's important not to panic. So part of your training to being a lawyer is not to panic and when something unexpected occurs. You're being trained to anticipate that things are going to go wrong and have backup plans when things do not go as expected. So for example, practice handwriting your exams in case your laptop crashes. Stay calm and think your way through the problem. You can try and reboot your computer. Just stay calm, and if it doesn't reboot right away and something happens, raise your hand, start writing. Because your exam will be saved at the point that your computer crashes or something happens. So they're able to pull that off. So don't worry about it, but have that backup plan. What's going to happen if I get into class and my exam soft's not working or my computer's not working? Well, if you've written out exams, then oh well, at least you can handwrite it. All right, so some common mistakes that I see all the time. Failing to carefully read and follow the instructions, that is a big one. Starting to write before analyzing the question and organizing the answer. And this is a common thing that I see, is that some students think they know exactly what's going to be tested on, and your professor might tell you what's going to be tested on, and then you just start writing, knowing that you're going to be fitting in the facts somewhere while you're writing. And that just doesn't work out because you're wasting time. Not managing your time properly and effectively, that's a big problem. Not paying attention to facts, or ignoring facts, that's even worse. That's a big thing. Like I said, you have to scrutinize every single fact on that exam. Insisting on finding issues must be in the exam. And I get this all the time. I see this all the time. My students think that I tell them what I'm going to be testing on, and I'll test in that area, but I won't tell them specifically, and then they put down all these things that aren't on the exam because they're not reading. And it's a common thing, all right? They're going to be testing on products liability, so I have to write everything on products liability. There might be one aspect of products liability that's not on the exam. So you're wasting your time. For example, was it put in the stream of commerce intentionally to harm somebody? If you're, I don't know how your torts professors are teaching, but if there's no intent there, then I'm not going to be writing on that. I might write on strict liability, I might write on warranties, I'll write on negligence. Ignoring issues raised by the facts because the issue would ultimately fail on the merits. I find this occurring with people who have experience in the law. So paralegals and people that are coming into law school, in practice, we're trained to kind of eliminate issues and focus on key issues, and that will carry over into law school where no, you have to write on everything. Failing to IRAC, that is a huge thing. Leaving out relevant rules of law, that's problematic. And then failing to use precise, accurate language in stating the legal rules and analysis. This is my pet peeve. I have facts in there for a reason. Use the exact facts. Don't paraphrase, because when you paraphrase, a lot of times with the heat of the moment, you're not paraphrasing correctly and you're adding facts. So the facts are there, use the exact facts. If it's a blue car, say it's a blue car. I mean, like I said, that's really common. Too many spelling errors, that's a big thing. Or I didn't talk about this, giving a general dissertation on the law rather than answering the question asked. And the term is horn booking. So, you know it's going to be on negligence, so you're going to write everything on negligence and state all the rules, and there's no analysis. That's horn booking. That's not what we want. We don't want a regurgitation of the rules without any analysis. All right, the key to effective essay writing is to practice essay writing. Do not outline. And what I mean by that is don't outline your exam. All right, I've had students who will take their approach outline and put it in their exam and then turn that in. You're not outlining. Outlining or issue spotting will not help you improve your legal analysis and writing skills. Also, too, I know that a lot of students are pressed for time, and what they do is, I'm just going to issue spot this exam as opposed to write it. I'm telling you, get in the habit now of writing as many exams as you can, because it really, there's only so many ways that a certain area is going to be tested, and the more exams you get your hands on, the more ways that you know that this area can be tested, and you're writing, you're going to be ready for anything. And so being prepared is the key thing. Again, the more practice you get, the more confidence you will have, and do not wait till the last minute. If your professor tells you that they will accept exams from you and they will look at them, take them up on that offer. Not a lot of professors do that. And so what you want is that professor's feedback before you take your final exam. Plus, it's getting you into the habit of essay writing. And one of the key reasons why students do not pass their classes or do not do well or do not pass the bar exam is because they're not practice writing enough. And that's a simple fact of the matter. All right, with that, any questions?
Yes.
Yes?
These are mechanical kind of questions that I had. I tend to write out plaintiff, defendant, and I see in a lot of the examples will just have P or D. Can you just tell me what's the best approach to that? Is that a professor by professor?
Okay, so you're going to have to ask your professor for his or her preference. I want my students to abbreviate. So if we go back to the slide where I showed you the title of the case, and it's Pam, P in parentheses, versus Don, and then D in parentheses, just put P and D. I mean, any time that you can abbreviate, in my philosophy, it's a time saver. And I don't think many of your professors are going to object to that. I know the bar doesn't object to it, as long as you write it out first, then put in parentheses what you're going to be abbreviating it as, and then put the end parentheses. So, for example, I teach civil procedure, and so one of our things is subject matter jurisdiction. Well, my student shouldn't have to retype subject matter jurisdiction over and over and over again. So if they head note subject matter jurisdiction and then put in parentheses SMJ, M parentheses, I'm good with that. Just be consistent.
Second, you kind of touched on a little bit on outlining, when you said don't outline, in your essay. You should be writing complete and full sentences, correct?
In your essay, you need to write full and complete sentences, yes.
And then can you talk a little bit, just to touch on it, filling in the blank for me, on each of the elements within a particular issue? You've broken it down, you've analyzed it, a conclusory statement on each one of those, and then the overarching conclusion. Can you talk a little bit about that, or am
I'm not sure what you mean.
I'm getting conflicting direction, so I'm trying to get some clarity. So let's just take assault because it's simple. If you've got the different elements within assault, you're going to give the overarching definition of assault, then you're going to take each one of those elements and you're going to lay out, how the facts play out. Yes.
Which each element, right.
With each element, and then you conclude whether or not this element has been met. And then overall, looking at all of these, yes.
So, it's going to be a professor by professor. I would rather have you conclude, if you're talking about assault, go through the elements and then, analyze each element and then put a conclusion as to whether or not an assault has occurred. I think, in my opinion, doing it after every single element is a little bit too time consuming. But again, in law school, you're writing to your professors. So if that professor tells you to do something, you do it their way because you want to pass the class. Knowing that another professor like me won't have you do that, I just want you to go through, take that rule, get the elements, do a factual analysis as to each element, and then come to a conclusion. Did an assault occur? And then move on to the next issue. The best way to do that and to see what your professor prefers is to ask your professor and then see if your professor will take a practice exam from you. And that way, if you do a practice exam and you spend time with your professor going over it, then he or she should be able to tell you, no, that's not how I want you to do it. Because you might be hearing something in class differently than what they really want. So always ask. I don't think most of the professors here would turn away a student who's doing that. I mean, I know I wouldn't. One of my students brings me a practice exam to go over. I go over a practice exam with them.
That's fine, professor for professor. What about when we take the bar?
The bar exam is completely different. You're not doing little mini conclusions after each element.